seeking the following reliefs. One, an order directing the defendant to formally and lawfully communicate to the claimant the termination of the contract employment of the claimant with the defendant commenced on the 2nd day of May 2018. Two, an order directing the defendant to pay the claimant all his emolument and other benefits with effect from 21st of June 2021 until the eventual termination of the claimant's employment. Three, an order for the payment of the sum of 3 million naira by the defendant to the claimant for the breach of the fundamental rights of the claimant in the defendant's non-observance of the rules of natural justice expressed in the defendant's human resource policy and procedure manual and the Constitution of the Federal Republic of Nigeria, 1999. Also, a declaration that the defendant acted unlawfully by failing to communicate to the claimant the substance, the findings, and resolution of the purported unfounded and substantiated allegations against the claimant. 5, a declaration that the defendant acted unlawfully by failing to accord the claimant the right to put up a defense against the defendant's allegations as stipulated in the defendant's human resource policy and procedure manual. 6, a declaration that the claimant is indebted to the claimant, the defendant is indebted to the claimant, and all the claimant's salaries and other emoluments for the period between 21st June 2021 till the eventual termination of the claimant's employment with the defendant. And lastly, cost of this suit in the sum of 2 million naira only. The claimant's case is that he is a licensed medical lab scientist employed by the defendant on the 2nd day of May 2018 and was confirmed on the 5th of November 2018 that he served diligently. On the 21st of May 2021, defendant issued a memo suspending claimant over an alleged conspiracy to defraud. On the 24th of June 2021, the suspension was converted into an indefinite suspension pending investigation. Claimant was never informed of the substance of the allegation. He was not given any opportunity to participate in, defend, or even know if an investigation took place. Defendant failed to communicate the outcome of any supposed inquiry. His case is that the defendant acted in gross violation of his own HR policy and procedure manual. The indefinite suspension without process contravenes Chapter 4 of the Constitution, especially provisions on fair hearing and due process. Claimant's career progression and ability to secure new employment were stalled due to the unresolved suspension. The defendant's silence has left the claimant in limbo for over a year, depriving him of his salary and severance benefits since 2021. Since 21st of June 2021, the claimant's counsel wrote on the 3rd of June 2022 and again on the 5th of August 2022 demanding resolution of his employment status, but the defendant ignored both letters despite proof of delivery. It is claimant's position that the defendant's failure to resolve the matter shows there was no genuine investigation. The claimant led evidence himself as CW1 in respect of the above claims. He tendered as exhibits which are admitted and marked as Exhibit C1 to Exhibit C7. The defendant's case, on the other hand, is that he denies most of the claimant's allegations except admitting the employment relationship and some uncontested facts, that the claimant was alleged to have shown poor diligence, absconded from duties, engaged in insubordination, and was repeatedly queried in the years 2018 to 2019. And between 2020 and 2021, the defendant noticed a downturn in laboratory revenue, data irregularities, and manipulation of records. Internal audit revealed discrepancies, inventory issues, and missing revenue. The claimant, among other staff, were interviewed but gave unsatisfactory responses. He was suspended on the 21st day of May 2021 pending investigation and later placed on indefinite suspension, that is the 24th of June 2021, due to the scale of data software issues. After investigation, the defendant concluded in July 2021 that the claimant was culpable for malpractices with 1,080,300 naira unaccounted for and terminated his employment by letter dated the 27th day of July 2021. The defendant states that the claimant was duly informed, carried along in the process, and participated in interviews. The claimant allegedly failed to return company The claimant allegedly failed to return company property or complete the exit clearance, preventing processing of final benefits. The defendant argues that it is not indebted to the claimant for salary/emoluments after June 2021, as his appointment was terminated. The defendant views the claimant's suit filed a year later as malicious, frivolous, vindictive, and lacking merit, and urged the court to dismiss it with substantial cause. One Dr. Ephraim testified as DW1 and tendered 7 documents admitted and marked as Exhibit D1 to Exhibit D7. In the body of the judgment, the defendant's final written address is here, and also the claimant's final written address, all embodied in the body of the judgment. So I'll go straight to the preliminary issues and the court decision. The claimant objected to the admissibility of Exhibit D6, which is the termination letter dated 27 July 2021, on the ground that he was unaware of the letter and it was never served on him. In response, the learned defense counsel submitted that the claimant was duly served with the letter. It is both pleaded and materially relevant to the case as it confirms termination of employment. In addition, the learned defense counsel argued that the law is settled, that for a document to be admissible in evidence, it must be relevant to the issues in controversy. It must be pleaded by the party relying on it and must be admissible in law. He cited Adeye versus Bangboye, Malam Ogu versus Mani Technologies citations were all provided. Furthermore, Exhibit D6 was specifically pleaded in paragraphs 30, 31, 33, 34, and 38 of the Statement of Defense. That the document is clearly relevant as it relates to the termination of the claimant's employment, which is the subject matter of this suit. A termination letter is not a document made inadmissible by any statute. That since the defendant had always formally communicated with the claimant on employment matters, which is Exhibit D1 to D5, it is therefore improbable that termination would not have been formally communicated. The claimant's case of ignorance or lack of service is described as malicious falsehood intended to suppress a material document and mislead the court. The claimant's contention that he was unaware of the letter and that it was not served on him does not affect the admissibility of the document. On the part of the court having gone through the document, it is a termination letter, it was pleaded, and it is relevant in determining how the claimant's employment was terminated. Accordingly, the court is of the view that Exhibit D6 is relevant, pleaded, and admissible in law. However, the weight and probative value the court will eventually attach to the document will be at the judgment stage, after evaluating the totality of the evidence I so hold. So, to the court decision, the law is that declarations must be proved on the strength of the claimant's evidence, not the weakness of the defendant, or even its admission. See Dumes Nigeria Limited versus Nwakaba, relying on Bilu versus Eweka, and Mutunwase versus Shoronugbe. Citations all provided, where the court held that where the claimant is praying for a declaratory relief, he must prove his case on his own evidence and not the evidence of the defendant. The court will, however, look at the declarations and the orders simultaneously in the judgment. The claimant is seeking for a declaration, which is the first relief, that the defendant acted unlawfully by failing to communicate to the claimant the substance, the findings, and resolution of the purported unfounded and unsubstantiated allegations against the claimant. In proof of this relief, the claimant averred in his statement of facts, paragraph 6, that he was suspended by Exhibit C3 on the basis of an ongoing investigation for conspiracy to defraud the company by engaging in some malpractices contrary to public policy. Also, by Exhibit C4, the company wrote about a month later that the suspension was now an indefinite one on the grounds that the investigation would take longer than expected. It is claimant's position that the substance, the findings, and resolution of the purported unfounded and substantiated allegations were never communicated to him. During cross-examination, the claimant admitted that the defendant had formally communicated and passed all information for his attention in the past, such as the queries he was issued, the suspension letter, and the indefinite suspension. According to the HR policy Exhibit C5, page 57, the policy provides that for a thorough and fair investigation, an employee must be suspended and he should be informed of the reason in writing. And I quote, "Following suspension, an employee shall be advised in writing of the outcome of any investigation which relates to them personally." End of quotation. In the instant case, claimant has maintained that he never got the substance, the findings, and resolution of the allegation communicated to him. Now, on the part of the defendant, he relied on Exhibit D4 and D5, which incidentally was tendered by the claimant and marked as Exhibit C3 and C4 respectively. And his defense was that a month later, a termination letter was issued, marked as Exhibit D6. The court noted that having suspended the claimant indefinitely and having admitted during cross-examination that claimant was interviewed between 8 and 15 times before a panel, the defendant did not present a single written report on the findings, neither was the claimant communicated with a copy either, where he acknowledged. The court noted that the defendant failed to tender any document in writing of the outcome of the investigation in compliance with the HR policy. The defendant also failed to discharge his burden of proof, which was key to establish that the claimant was part of the process of the investigation. Besides, the court took a cursory look at Exhibit C4, the letter of indefinite suspension, and noted that the last paragraph of Exhibit C4, which was the letter of indefinite suspension, concluded thus, and I quote, "We wish you the best in your future endeavors." End of quotation. The defendant, by this paragraph, had skipped some other steps as prescribed by Exhibit C5, the HR policy. This court is convinced that the defendant failed to comply with the HR policy by advising the claimant in writing of the outcome of the investigation. Rather, the letter of indefinite suspension put a close to the investigation by the wordings of the last paragraph, I so find. The relief sought for a declaration that the claimant acted unlawfully by failing to communicate to the claimant the substance, the findings, and resolution of the purported unfounded and unsubstantiated allegations against the claimant. Relief 1 succeeds, I so hold. Relief 5 and 3 sought is for a declaration that the defendant acted unlawfully by failing to accord the claimant the right to put up a defense against the defendant's allegations as stipulated in the defendant's HR policy and procedure manual, and also an order for the payment of the sum of 3 million naira by the defendant to the claimant for the breach of the fundamental rights of the claimant in the defendant's non-observance of the rules of natural justice expressed in the defendant's HR policy and procedure manual and the Constitution of the Federal Republic of Nigeria. Parties are in agreement that the claimant was on indefinite suspension, and by the HR policy, at clause 9.3, it provided for a 4-step process of investigation after an employee is put on suspension. 1, which is the investigation, the action points. 2, another investigation, the preliminary interview. This subsection is an investigatory meeting, not an interrogation. It reviews the evidence and asks for comments for clarity. This will confirm the action taken in writing, even if no sanction will apply. The 3rd step is investigation, examining the evidence. Upon such examination, if misconduct has occurred, then the employee is informed of a disciplinary hearing. If the evidence proves no case, the employee is informed. All the actions will be confirmed in writing, and a report shall be made detailing all the evidence and witness statement. The 4th step is the employee's comment, which comprise the employee stating his case on the evidence and information put forward. And based on the evidence, the investigation committee would assess whether it is a disciplinary offense and assess the employee's past record. Finally, the meeting is adjourned with a reasonable time scale to reconvene, and the employee is provided with a signed copy of the meeting notes. From the comprehensive reading of the HR policy, the defendant complied with the HR policy to the extent that after the initial suspension, which is Exhibit C3D4, the claimant was notified in writing that the suspension had transmitted to an indefinite status, which is Exhibit C4/D5. However, there was no evidence before this court that the details of the further meetings the defendant referred to in paragraph 1 of Exhibit C4D5 was ever transmitted to the claimant. To the claimant, this was the last communication he had with the defendant, while to the defendant, a termination letter was written later in July, severing the employment contract, which is Exhibit D6. Now, the question before the court is, how was the claimant confronted with the allegation to enable him provide a defense at the investigation proceeding in compliance with Exhibit C5, page 57 to page 60? The claimant has maintained that he was never carried along in the investigation process. On the other hand, the employer/defendant who conducted all the process has been quiet about this. This court is equally appalled that an employer who had records of the queries issued to the claimant in 2018, 2019, and had evidence of how they were delivered both by hard copy and email is before this court without a single evidence of how the investigation was conducted. DW1 furthermore, under cross-examination, testified that the defendant had between 8 and 15 interviews with a complement of 9 panel members, and he failed to tender a copy of the findings as stipulated in the HR policy, or a signed copy of the findings, which ordinarily the claimant was expected to have a copy. It is tried law that averments in pleadings are not evidence. They mainly highlight the evidence that the party is likely to present so that the other party will not be caught unawares or unprepared. Consequently, averments in pleadings must be proved by evidence, except where they are admitted by the other party. See NAS Limited versus UBA PLC, citations are provided. This court has alluded times without number, in this case, that the defendant has failed in providing evidence to facts pleaded. There is no evidence that this termination letter, Exhibit D6, was sent by email to the claimant, just as queries were sent in the past during the course of his employment. Defendant has no evidence that the document was signed for and collected by the claimant. Neither is there evidence that the letter was mailed to the last known address of the claimant. In the absence of proof that the termination letter was delivered or received by the claimant, there is no way the content could have been complied with, that is, to complete the exit clearance processes. It is also remarkable that defendant, upon receipt of Exhibit C6 and C7, which are 2 letters from the claimant's counsel requesting for, and I quote, demand to resolve the employment status of your staff, in bracket, our client, end of quotation, and a reminder letter which were all tendered without objection, to which the defendant ignored or neglected to respond to under the guise that as at the time of receipt of the letter, the claimant was no longer his staff. The letters in question were aimed at resolving issues pertaining to the status of the claimant's employment. This court is aghast that the defendant were indifferent to utilize this opportunity to settle this matter after discovering that a huge amount of 1,080,300 naira was unaccounted for and allegedly traced to the claimant. The defendant has provided convincing facts to sway the mind of the court to his favor, but unfortunately, he has no evidence to support his facts. It is common knowledge that civil cases are decided on the preponderance of evidence or on the balance of probability, so that, as rightly argued by both counsel, the burden of proof rests on the party who asserts the existence of a certain fact to adduce credible, cogent, and satisfactory evidence in support of, in proof of such assertions. See Section 131 to 134 of the Evidence Act and Magaji versus APC citation provided. It is therefore not in doubt that the defendant failed to afford the claimant the right to defend himself as provided in the HR policy. I so declare and hold that in view of the defendant's breach of the fundamental rights of the claimant in non-observance of the rules of natural justice expressed in the defendant's HR policy and the Constitution of the Federal Republic of Nigeria 1999, the courts have held that the party cannot benefit from his own wrong. See Bataha versus West Construction Company Limited citation provided. So in other words, equity will not permit a party to benefit from his own illegality. Having failed to show the step-by-step procedure of the HR policy which he drafted for compliance by both the employees and he, the employer, Willie 3 succeeds to the extent that the claimant is entitled to 500,000 naira only from the defendant, I so hold. The claimant is also seeking a declaration that the defendant is indebted to the claimant and owes the claimant salaries and other emoluments for the period between 21st June 2021 till the eventual termination of the claimant's employment with the defendant, which is relief 6 and 2 as listed in statement of fact, and is also seeking an order directing the defendant to pay the claimant all his emoluments and other benefits with effect from the 21st day of June 2021 until the eventual termination of the claimant's employment. The court has noted earlier that the period of reckoning from the 21st of June 2021 is 1 month after the claimant was placed on suspension. By Exhibit C3, the claimant's suspension was with effect from 21st of May 2021. The indefinite suspension commenced on the 24th of June, and that is the period under contention now. This relief sought is expected to run from the 21st day of June 2021. In other words, the claimant has admitted that the salary for May was paid. In Exhibit C3, claimant was paid while under suspension as collaborated in paragraph 21 of the statement of defense, which is, and I quote, the initial period of absence due to the suspension, end of quotation. See paragraph 2 of Exhibit C4. The defendant, on the other hand, has stated in paragraph 22 of the statement of defense that upon conclusion of investigation, the claimant's employment was terminated. The defendant went further to state in paragraph 23 to 31 of his statement of defense how the investigation was carried out with the claimant's participation and eventual termination. By paragraph 23 of the same statement of defense, he further averred that in the termination letter, the claimant was expected to complete his exit clearance process to enable the defendant process his final severance payment, which was never done. This cover up by the defendant to support why the claimant's final payment was never paid is faulted in this judgment. There was no ounce of evidence tendered by the defendant to support all the litany of facts pleaded, although during cross-examination, DW1 testified that the claimant was invited verbally and his representation was also verbal. Defendant was asked if the claimant was present when management made this resolution, and his answer was he was not present but collected the letter same day, end of quotation. The onus is on the defendant that insists that the claimant received the termination letter to adduce evidence to prove that the claimant received the letter and to show what the mood of receipt was. All this the defendant failed to do. The court is left to imagine how that letter was delivered and received. The court cannot base its decision on speculations or go on a voyage of discovery in the resolution of cases. See Federal Mortgage Bank versus ECBO citations all provided. The claimant, having shown by credible evidence that he was placed on indefinite suspension, the burden rests on the defendant to prove that he delivered the termination letter to the claimant and properly terminated the contract of employment between them. It is the considered view of this court that the defendant has failed to discharge the burden placed on it in this regard. Consequently, this court finds that the claimant is entitled to a salary for the month of June 2021 for the reason that the right of the claimant to be paid his salary during suspension is striked. See Akinyanju versus University of Ilorin, citation provided, where the Court of Appeal held that suspension means to defer, to lay aside, to hold in abeyance. It also means to halt halfway, but not to bring to an end or to terminate. On the nature of suspension in Shell Petroleum versus Emehuru, the court also held that suspension places an employee on hold, awaiting recall or termination. And during that period, the employee is not free to take up other jobs. Also, in Globe Motors Holdings versus Oyewole, the Court of Appeal held that a suspended employee remains in continuous employment and is entitled to full wages during suspension unless the contract of employment or suspension letter clearly states otherwise. Where the suspension letter or contract is silent on pay, the employee must be paid full emolument. In the instant case, the claimant suspension letter Exhibit C4D5 made provisions to pay for May salary, but was silent on June 2021 salary. A cursory look at the appointment letter, which is Exhibit C1, nor HR policy Exhibit C5, neither provided for suspension without pay. Therefore, the indefinite suspension has no legal effect on the claimant's right to a salary. Nigerian employers often misuse suspension as punishment, even before investigation is concluded. International best practices endorsed under the Third Alteration Act requires that suspension should not be prolonged. It should not be without pay, and reasonable benchmark is about 30 days. In Ogbaka versus Oha Microfinance Bank Limited, a decision delivered by the NICN in 2022, citations are all provided. The NIC held that suspension without pay beyond 1 month is unreasonable, unlawful, and inhumane. Employers must pay arrears where such occurs. The court also held that effect of prolonged suspension, even with pay, can amount to constructive dismissal due to the mental stress and uncertainty imposed on the employee. The claimant is seeking emolument from June 21st until the eventual termination of the claimant's employment. The courts have held on numerous occasions that an employee would only be paid for the period he served his employer. Hence, an employee cannot claim for salaries that are not earned. CCB versus Nwankwo, and Balogo versus Union Bank, and Olatubosun versus NISA Council. Citations are all provided. Parties are in agreement that the indefinite suspension commenced from the 24th of June, and this court has no proof before it when the defendant called off the suspension, except for a termination letter dated July the 27th. Defendant had listed a lot of challenges why the suspension became indefinite, such as review of much data, review of key video evidences which were held by a former IT officer. By the test of a reasonable man, this court believes that all this process could have been tidied up in about 8 to 15 panel sittings as testified by the defendant during cross-examinations within 3 months to enable the claimant know his fate. By page 59 of the HR policy, bullet point 456, the employer should have gotten enough evidence and assess whether the allegation alleged was a disciplinary offense, whether it was a misconduct or capability issue. And by bullet point 11, 12, and 13, the defendant should have adjourned the meeting, advised the employee of a reasonable time scale to reconvene, provide the employee with a signed copy of the meeting notes, then reconvene the meeting and inform the employee of the decisions made and the reasons. On this entire process, the defendant has failed to show that he carried the process diligently, which amounts to a breach of the contract of employment. As earlier stated, going by reasonable man's test in Pam versus Mohammed, where Toby J. SC at page 69, paragraphs 8 to 6 stated, and I quote, "A reasonable man and the impartial observer mean the same. They mean a complete stranger, an unbiased person to the proceeding. A reasonable person is a person with reason, having a faculty of the mind by which he distinguishes both falsehood, good from evil. A reasonable person is a fair, proper, and just and unbiased person. An impartial observer is not partial. He favors neither the plaintiff nor the defendant. He is disinterested in the matter, as he treats both the plaintiff and the defendant alike. He is an unbiased person. Both the reasonable person and the impartial observer are like hypothetical legal standards for determining or judging fairness, fair play, and equity. The test of the reasonable man in Nigerian court is no more than the man at the Clapham Junction in London, but one in anywhere in the Nigerian cities." End of quotation. So by the above dictum, the process should have taken a reasonable man at least 3 months to accomplish in view of the challenges enumerated by the defendant. Unfortunately, that was not the case. So in consonance with the above reasoning, this court is convinced that the claimant is entitled to all his emolument and other benefits with effect from the 21st day of June 2021 to August 2021 only, which is a period of 3 months. I so find and hold. Claimant is also seeking for an order directing the defendant to formally and lawfully communicate to the claimant the termination of the contract employment of the claimant with the defendant commenced on the second day of May 2018. By the statement of facts, paragraph 3 and 4, claimant averred that he was initially employed by the defendant company on the second day of May 2018 and confirmed on the 5th of November 2018. He tendered his offer of employment letter and confirmation letter as Exhibit C1 and C2. The defendant corroborated this fact and tendered same employment and confirmation letters as Exhibit D1 and D2. Claimant is before this court seeking an order directing the defendant to formally and lawfully communicate to the claimant the termination of the contract employment of the claimant with the defendant commenced on the second day of May 2018, which is the same date of employment. This relief sought is unknown to this court, and the claimant has not adduced evidence or proffered any argument or authority to convince this court to grant an order that the date of employment is the same date of termination. This relief fails and it is dismissed, I so hold. The cost of this suit is assessed at 350,000 naira only. All sums hereby awarded in this judgment shall be paid within 30 days from the date of this judgment, failing which simple interest of 10% per annum shall apply. The judgment is entered accordingly and is signed. So this is the judgment of the court.
We are most grateful, my Lord, for the judgment just delivered.
We are most grateful, my Lord. We are most grateful for my Lord's well-considered judgment. We are most grateful.
Okay.